In most cases, no. Spying on your spouse is illegal in North Carolina, even while you are still married. There is no marriage exception in the wiretap laws. We understand why you're asking. Something feels wrong and you want to know, so here's where the legal lines sit and the safer ways to get your answers. 3 layers of law come into play, and being married exempts you from none of them. First, federal law. The Electronic Communications Privacy Act makes it a crime to intentionally intercept, use, or share someone else's wire, oral or electronic communications, calls, texts, emails, video calls, voicemails. A companion piece, the Stored Communications Act, makes it illegal to access someone's stored communications without authorization, like logging into your spouse's email. Courts have consistently refused to carve out an exception for spouses. Second, North Carolina law, our Electronic Surveillance Act makes it a Class H felony to intercept a communication without the consent of at least one party to it. North Carolina also has computer trespass statutes covering unauthorized access to another person's computer, phone, or network, and a separate statute making it a crime to install an electronic tracking device to follow someone without their consent. Third, civil law. Separate from any criminal charge, North Carolina recognizes the tort of intrusion upon seclusion, an invasion of privacy claim your spouse can bring against you personally. Our Court of Appeals has allowed exactly that kind of claim, where a hidden camera was placed in an estranged spouse's bedroom. The penalties are serious on both sides. Federally, violating the Electronic Communications Privacy Act can mean fines and up to 5 years in prison, and the person you spied on can sue you for damages and attorney's fees. In North Carolina, illegal interception is a Class H felony, and again, your spouse can sue you civilly on top of it. But here's the cost that lands first and hardest. Illegally gathered evidence usually cannot help you in your divorce case. It hands your spouse leverage, and it damages your credibility with the very judge who is going to decide your custody, your support, and your property. You walk in as the wronged spouse, and you walk out as the one who committed a crime. Generally, yes, if you are part of it. North Carolina is what's called a one-party consent state. A recording is lawful as long as at least one participant in the conversation consents, and you count as that one party. So you can typically record your own conversations with your spouse, in person or on the phone. What you cannot do is record conversations you are not part of, your spouse talking to a friend or to someone they may be seeing. Planting a recorder in the car or the house to capture those conversations is exactly what the wiretap laws prohibit. One caution: if a call crosses state lines into a state that requires everyone's consent, the analysis gets more complicated. When in doubt, ask before you press record. This is the grayest area in the whole field, and the honest answer is that knowing the password is not the same as having permission. Consent is the dividing line under both federal and North Carolina law. If you have always shared an email account or freely used each other's phones, there is a reasonable argument that your access was authorized. But consent has limits. One-time sharing is not ongoing consent. A password your spouse gave you years ago to check a flight confirmation does not authorize you to monitor that account today. Consent can be revoked, and once you separate or once your spouse changes the password, any earlier permission is almost certainly gone. And shared devices are not blank checks. A family computer you both use is a different thing from your spouse's personal password-protected phone. Guessing or cracking a password looks like unauthorized access, and that is where the computer crime laws bite. If a piece of information matters to your case, ask your attorney how to get it lawfully rather than logging in. Be very careful here. North Carolina's cyberstalking statute makes it a crime to knowingly install an electronic tracking device to track a person's location without their consent. There is an exception for tracking a vehicle titled or leased in your own name, but the safe assumption is that it is narrow. If the car is your spouse's or the title situation is murky, planting a tracker can be a crime. And how that exception applies to a jointly titled vehicle is a genuinely unsettled, fact-specific question. Do not test it without legal advice. The same goes for sneaking a phone into the trunk, hiding a tracking tag in a purse, or switching on location sharing without your spouse's knowledge. Following someone electronically without consent is treated far more harshly than most people expect. Monitoring apps, the ones sold to secretly forward someone's texts, calls, and location, practically advertise a wiretap violation. Installing one on your spouse's phone intercepts their communications without consent, which is precisely what the federal and state statutes prohibit. Keyloggers capture passwords and private messages from a shared computer, and using one to get into your spouse's accounts runs into both the federal stored communications rules and North Carolina's computer trespass laws. Don't. Hidden cameras, you will sometimes hear that video without audio is fine. That is an oversimplification. Audio recording triggers the wiretap laws, and even silent video where your spouse has a reasonable expectation of privacy, a bedroom or a bathroom, invites an invasion of privacy claim. A camera in your own home is not a free pass once you are recording an estranged spouse's private life. And smart speakers, features that let someone listen into a home remotely, raise the same problems as a planted recorder. Modern monitoring rarely looks like a private eye in a parked car. The common tools are location sharing switched on without your knowledge, monitoring apps hidden on a phone, Bluetooth trackers dropped in a bag, shared cloud accounts syncing your messages to a device your spouse controls, and smart home devices your spouse can reach remotely. Warning signs include a battery that drains unusually fast, your spouse knowing things they should not know, and unfamiliar apps or devices on your accounts. A few protective steps. Review which devices are signed into your accounts and remove any you do not recognize. Turn off location sharing you did not choose. Change your passwords from a device your spouse has never touched and turn on two-factor authentication. Untangle shared accounts with your attorney's guidance. If surveillance is part of a pattern of controlling or frightening behavior, that can support a domestic violence protective order. Your safety comes first. So can spying evidence be used in your divorce? Usually it hurts you far more than it helps. Even where a judge might see the material, you have handed the other side a weapon. Now the story is not your spouse's affair, it is your crime. Lawfully obtained evidence genuinely matters in North Carolina. Proof of marital misconduct can affect alimony, but the evidence is only valuable if it is clean. So here is how you get it. Hire a licensed private investigator, ideally through your attorney. They know where the legal lines are, and they make credible witnesses. Look at what is public. Social media visible to you can be screenshotted and preserved. Use your own records, like statements for joint accounts and documents in your own possession. Record your own conversations, because one-party consent means your interactions with your spouse can be documented. And use the court's tools. Once a case is filed, discovery, meaning interrogatories, document requests, subpoenas, and depositions, compels answers under oath. It is slower than snooping, and it is far more powerful. If you are tempted to spy, that instinct is telling you something important. Your marriage is in real trouble and you need information and a plan. Get both the legal way. At McCrary Pack, PLLC, Divorce and Family Law is all we do. We help clients figure out what evidence actually matters, how to get it without breaking the law, and what to do next. Family law for Iredell, Catawba, Alexander, Caldwell, and Burke counties, where clients are neighbors, not numbers. The full guide is linked below. Reach out today, neighbor to neighbor.